Here we go, it's all about you, it's all about me, so don't we do making art, you and me, trying to find something to believe, because I'm running wild, like running free, still got a lot of shit left to see.
Hi guys, welcome back to my channel. It's your girl Britannia, and here we're gonna try something new.
And a certain kind of ignorance, a very willful ignorance, on the part of their co-citizens.
Hi guys, if you're not new to the channel, and if you are new to the channel, hey, it's your girl Britannia, and we're here back for another video. And as I said at the beginning, we're here to try something a little bit new. And today we're going to be doing Policy Power Hour with your policy princess. That's me. So today, instead of just talking about film or TV, we're going to be talking about TV as it coincides with policy. So today we're going to be looking at the Ashley Madison case. If you guys are unaware, of course I'm going to give you a brief overview and look into what I'm talking about. And what I'm talking about is the new Netflix documentary docu-series. I think it's 3 episodes long, or maybe 3-4 episodes. And the docu-series basically covers a controversial scandal that occurred in the summer of 2015, which was related to the company Ashley Madison, which was a dating, or it still exists, which is a dating platform or a company that offers the service of a dating platform for married individuals.
I've never been cheated on in my life, at least that I know about.
You've been cheated on, you just don't know. We've all been cheated on.
70% of relationships have, infidelity attached to it one way or another. So most people, at one point in their lives, experience being cheated on or cheat on their partner.
I know you're a businessman, but I also know that you're a human being too.
Absolutely, I am.
When that man was crying, I was watching you.
I feel terrible.
I saw something in your heart.
I genuinely do feel terrible for the two of you. And we say it right on our website, and I say it all the time when I speak to people, before you go down this path, because it is a path, make sure you can't repair your marriage. Try the communication, try seeking counseling, whatever you can do, try and fix your relationship. But if you've already made the determination to step outside your relationship, then we've built a service that allows you to do that.
I feel a heart inside of you that you're trying to cover up right now.
I have a heart.
I know.
I do.
I feel it.
Yeah. You can see how that idea in itself is probably very controversial to a lot of people. Well, we're going to add GDPR into that mess. Now, when I say there was a scandal, and when I mention the word or phrase or term GDPR, first, the scandal covered a data leak from the company of consumers' personal information. So that was clients' email addresses and other sensitive information that was leaked, and this was the basis of the scandal. And in conjunction, as I said before, we're going to be talking about EU policy called GDPR, which relates to data and data protection. So, if you're interested, let's get into the video. Of course, as always, when it comes to these more academic essay type videos, we're gonna leave sources in the description. So if you're interested in any of that, please go check it out. Netflix, in what I can only assume is a part of like a long-term business goal to diversify its business services, Netflix has started to invest quite a lot into producing Netflix original docuseries, or at least acquiring them. So, some infamous Netflix docuseries from the past that have been produced and that has like garnered like viral media or social media attention in the very least, from what I can see on my For You page on TikTok, has been one, The Tinder Swindler, and that is a documentary on a notorious fraudster and scammer who would target women on Tinder, vulnerable women, and then parade around and commit fraud, this very affluent lifestyle in the hopes of ensnaring women to loan him money that he never had any intentions of paying back. So that's that one. Oof. The second one, Our Father, and now this is a breakdown of the actions of one Indiana doctor who conspired to spread his DNA.
Be nice.
I'm finding it.
It take you that long to
It
find
does. It does.
I'm trying to be real cute with the words for YouTube today. he conspired and did in fact spread his DNA by violating the rights of his fertility patients and their consent. And the last and my personal favorite is the college admissions scandal. Now, this docuseries is a docuseries focused on one man in particular behind the cheating and bribery scheme for Ivy League colleges that occurred, what was it like? I feel like back in 2019, I think the story broke out, but it concerned parents, wealthy, affluent parents, bribing and essentially committing fraud by faking documents and lying to Ivy League admissions on their admissions applications in order to get to Ivy League schools. So notable Hollywood celebrities that were caught up in that scandal, and probably which elevated to a scandal of that magnitude to which Netflix would want to cover, were celebrities like Lori Loughlin from Full House, and Felicity Huffman from Desperate Housewives. I love Desperate Housewives though. we should talk about Desperate Housewives on this channel at some point. I've rewatched that twice on Netflix at this point. I love Desperate Housewives. And because of those actions, they faced criminal offenses. So I've watched all of those series, and honestly I have enjoyed those docuseries quite a bit. And now amongst this year's new prolific Netflix docuseries comes Ashley Madison, the SEX, Lies and Scandal. That's the title. Ashley Madison was obviously marketed towards a demographic primarily of married men who would be interested in a social media dating platform. The marketing twists and commercial standout that would set Ashley Madison apart from other dating platforms or similar services around that time would be its constant promises of discretion in this marketing campaign. On the 15th of July, 2015, the dating platform had a breach, and that impacted up to 30,000 of the platform's customers. The documentary begins with the media scrutiny that the company befell to from the very beginning of this, widespread media campaign within Canada and within North America. Media and public opinion, unsurprisingly, did not react positively to the idea of the company or its marketing campaign. It made a lot of people sore. However, quite ironically, that negative feedback also helped to fuel the marketing campaign to reach as many eyes as it did, or as many ears from all the people who were whispering about Ashley Madison, the site for affairs. So this outrage fueled the company's success, and soon everyone went from whispering about Ashley Madison to loudly complaining about their disgust for the affair website, or proclaimed disgust, because as we see, millions and millions of users eventually did flock to the platform. The site proudly boasted some 37 million users at the time of the data breach. And this data breach was caused by a hacker group that named themselves the Impact Team. But before we go down the road and we untoil and unwrap the story of what happened that summer in 2015 and what Avid Life Media, which is the company that owned Ashley Madison, and Noel Biderman, whose name comes up a lot in the Netflix docuseries, he was the former CEO of Ashley Madison during that time, from the beginning up until the eventual kind of downfall of the company due to the scandal. He was the guy in charge. And as I said, before we get to all that, we have to get into the policy aspects. So we have to talk about data protection. To be able to fully understand and appreciate why this one story actually is so very interesting and important and says a lot about policy and the legal framework of the world at that time, and the importance of policy when it comes to data protection or technology in general, and why that is so important, I have to give you guys a thorough background of certain things for you to really understand and appreciate. So let's get into that. Now, why do I keep saying data protection, data protection? I keep using the word data, data, data. Obviously, we know that it was a data breach. So I've already mentioned the term data protection once or twice in response to the data attacks or data breach experienced by Ashley Madison. And data protection, which you may all know, but I am here to reiterate anyway to make clear for everybody who may not. So data protection would be like the general practice and methods and measures that everyone or anyone uses in order to protect their data, whether that be an organization, a person, whoever. And common methods and measures to protect your data, that's data protection, would encompass things like using passwords, biometrics, backup passwords, backup emails, using a second login to verify your first initial login. These things, it's data protection. Encryption, all of these things, these would fall into data protection. So one more key phrase that I have to give the definition for will be personal data. You will hear me use the phrase personal data quite a lot when I talk about data protection and the laws and regulations in which you can get in trouble for exposing someone's personal data. So this is the legal definition that's been drafted based off the regulations and laws that we're talking about. So that this is the definition that the law is working around. And as your internet bestie, has earned her law degree, which does not make me qualified to give anybody or anyone legal advice, and it does not mean that anything in this video constitutes as legal advice. Matter of fact, all of this information that I'm giving to you is only for informational purposes and entertainment purposes. So do with that what you will. And as your internet bestie with a law degree, we shall now look into the data protection laws of this jurisdiction which I am in, because that is what I am most familiar with. And there are other significant importance to it as well, but for that primary reason, I'm going to be talking to you about the data protection laws here in the UK, or the EU essentially. Prior to Brexit, which was official in 2021 after the referendum. I think the transitional period ended in 2021. So prior to the UK leaving the EU, the UK adopted EU law, and therefore we're going to be talking about EU law because that is what was relevant back in 2015 when we're talking about Ashley Madison, and that means we're going to be talking about the European Regulation 2016/679. What is that regulation? So that regulation essentially is law that was made and passed on the 27th of April in 2016. Listen to the dates now, people, okay? Pay attention to the dates. This regulation repealed the previous directive, which was originally the main source of data protection law in the EU and then therefore in the UK. That regulation that came into effect in 2016, which took over the directive, was called the General Data Protection Regulation, also known as GDPR. So whenever you hear me refer to GDPR, that is that specific law that was passed by the EU that I am talking about. Now, the GDPR, as I said, regulates the processing by any individual, company, or organization that processes personal data relating to individuals in the EU. So, doesn't matter as long as you're processing data that belongs to individuals in the EU, you would be subject to this regulation. Again, I have to give you some further definitions just so you guys are able to develop your understanding. What is a regulation and what is a directive? Both law, but what makes them different? I'm going to explain. Regulations are legal acts that apply automatically and uniformly to all EU countries as soon as they enter into force. They do not need to be transposed into national law. They are binding in their entirety on all EU countries. An EU country is any country that is a member of the EU. So for example, the UK, Spain, Italy, these are all countries that have joined as a part of the EU in order to share benefits of a singular economy. So if the EU Commission passes law, all that law affects every single member state when it's a regulation. When it's not a regulation and it's a directive, then those countries, England, Spain, Italy, for example, then have more freedom to choose how they comply to that law. So a regulation is more like hard law and a directive is more like soft law. And with the soft law, the countries, as long as they achieve a certain result, are kind of allowed to go about business how they choose and manage themselves how they choose in order to get the result. And regulations are more like micromanagers. You have to do everything step by step the way it's kind of ruled out in the manual. Hope that helps. So, with the new regulation that came about in 2016, after the Ashiman scandal, the idea of the regulation, or the idea of some of the advantages of the regulation, was the fact that it would harmonize data protection laws in the EU, speaking to the region, because as I said before, prior to 2016, each individual country was kind of allowed to do as they like in terms of how they went about protecting data as long as they reach a vague end result goal. But now all countries have to follow all of the same steps across the board. So that would benefit consistency. People would know what they're getting from in the EU, and they wouldn't have to ponder and wonder depending on which individual country, which is many countries in the EU, what law related to them. Also, the regulation brought about many new rights to protect consumers and to protect their data. It also carried over some very key aspects of rights for consumers from the directive into this new law, but as I said, making it hard law. And two bases of those rights which existed before and exist now in the General Data Protection Regulation is the legal basis for processing. That means that an organization must justify data processing based off of one of 7 legal bases that is described in a part of those laws, such as unambiguous and explicit consent. So organizations must have consent to retain your data. That's one. 2, the right to erasure. also known as the right to be forgotten. So an organization must respect a consumer or user's right to request for their data to be deleted. So that would make it so that companies, or at least organizations that are controllers, are not allowed to keep that data irrespective of a data subject's wishes or requests to stop. And a data subject is just whoever that data belongs to, a subject to which the data belongs. Now, I'm just going to briefly define to you a term that I've just used, a controller. So for the purposes of data protection laws under the directive and the regulation, so data protection law in the EU, organizations that use personal data from its consumers are divided into two central types in order to make it easier for the commission or the people or the authorities in charge of actually making sure, you know, these laws are followed and complied with. They have split these organizations in two. So those two types are called controllers and processors. The simplest definition and distinction between the two is that controllers, or organizations who use personal data, if that organization is a main decision maker in the way they control that data, or the purpose of which that data is being used for, then that is a controller. And controllers have to be held to a higher level of compliance responsibility because they are the ones who are essentially making all of the decisions, so they have all of the control over clientele personal data. Processors only act on behalf of the instructions of a controller. So that's why, so that is the split. Also, under law, that means that processors don't have the same ceiling of obligations or things that they have to do to make sure that they're abiding the law as a controller do, as I said, because controllers are more where the risk lies. That's where your attention is, because those are the people deciding what's with your data. In this publication from Clifford and Chance, many notable and very interesting things were mentioned and said at paragraph 12, which really does relate to Ashley Madison. So, according to the publication, it was said that the United States at the time, in 2012, had better data security policy than the UK, and this was apparently a very buzzing and controversial hot topic amongst legal academics or industry experts. They didn't specify, but it was a buzzing topic, the publication says. And I personally wonder if it was considered at the time in 2012 that the US or like North America generally had better data protection laws, then did this influence essentially the EU to want to propose these key policy changes to beef up data protection security? But further in the Clifford Chance article, but we're going to discuss what was further said in the Clifford Chance publication at paragraph 12, titled Security and Breach Notification. So, the publication highlighted the introduction of a breach notification regime, which would require controllers, do you guys remember who they are? Controllers to notify a data protection authority of any lost personal data within 24 hours of a breach and inform data subjects, which would be consumers, at least in Ashley Madison's case, their clientele, of that breach that may adversely, so negatively, affect their privacy or personal data. This was a part of the proposal for the General Data Protection Regulation that didn't come into effect until 2016. But this was proposed from 2012. 3 years and a few months change prior to the Ashley Madison scandal. Now, it kind of makes you think, well, what could have been if this policy was in fact far before the way it was proposed? In the Netflix docuseries, part of the salaciousness of this series is the sequence of events made by then CEO Noel Bitterman, and the actions he was alleged or confirmed by his emails and cases, I suppose, his civil suits, by multiple articles covered by the BBC, which I will put in my sources, that was claimed and alleged from participants of the docuseries who are also former employees. And as I've hinted at before, though the data leak occurred and was exposed on July 15th, 2015, the breach which caused the leak, so the access of the hackers to the data, did not originally occur on the same day. It occurred sometime before. And Ashley Madison and the CEO, so therefore, you know, the higher ups at Ashley Madison were aware that they So the higher ups at Ashley Madison chose to keep the data breach a secret for at least long enough to hire a whole team and liaise with the police about the breach. So instead of informing possible victims so that they would be able to bunker down or do anything they could do to brace for the potential leak, they kept the matter discreet. And if you've seen the docuseries, which I recommend you do, you would know that that leak, the harm that it caused and wreaked havoc to so many people, whether or not they were doing something romantically immoral, the impact, the harm that it caused was substantial. People lost their lives. So that policy that was not in place could have protected lives. And that is what we're always talking about when we're talking about policy. We are talking about lives. It is the fabric in which controls the threads that bind our society. They are the things that affect us, whether you know about it or not, if you're ignorant or not, it will still affect you. That is what policy is. It's impactful, its reach is everywhere, and no one can escape it. And that is why when we take our power by equipping ourselves with political knowledge and understandings of that framework, we then give ourselves the power in order to address these issues, to campaign for change, and to understand just generally what's happening to the world, to other people, and to ourselves. Now, you may argue, well, Britannia, what does it matter if the EU or the UK had this policy? It was not a... What does it matter if the EU or the UK had this policy? As the Netflix docuseries made clear, Ashley Madison was based in Toronto, so it's a Canadian company. So wouldn't Canadian law apply to it? Why are you yapping about EU law? I'm getting to it, okay? I'm playing with y'all. So, the reason why I'm discussing this specific policy, not only because I'm more familiar with EU law and UK law, but also because when anytime you're talking about policy as it pertains to international companies and entities, the waters get murky, bruh. The waters, they get murky. First, when a company operates and trades internationally, that company will therefore have an international consumer base. And having an international consumer base can largely affect what laws will affect your trading practices of that company and how that company is operated and managed. So that means you may still be subject to whatever civil litigation of the jurisdiction that your clientele is in. Second, most large-scale companies have various headquarters and staff and contracts from all over the world. So it is very likely that one jurisdiction would never apply to these companies. In conjunction with the headquarters that Ashley Madison had based in Canada, the parent company of Ashley Madison was primarily based in Cyprus. So, for example, under UK contract law, a contract may fall under English law depending on where the offer was formed, i.e. where acceptance took place, and that's under the postal rule. And these are the cases that form that rule in case you're interested in Googling that and finding out more about what that all entails. And then a second example is recently in the High Court of the England and Wales, it was held that a contract can, where the negotiations are complex, be made in two different jurisdictions. And I will leave the case law references. So these are now two examples of important circumstances which will, dedicate or change the jurisdiction of where a contract may lie. So it's not straightforward. Just because there's one headquarters in Canada doesn't mean that only Canadian law applies to Ashley Madison. As a matter of fact, do you recall the wording of the regulation that is in place now since 2016? That wording specifically stated that regulation applied to any organization processing EU personal data. So if there's EU clientele, which Ashley Madison surely did have because they had a basis in Cyprus, an EU country, and clienteles all around the world according to itself, including 50 countries, which some of them were a part of the EU. So if the based on that very specific wording of the General Data Protection Regulation, there was immense possibility for that policy to affect Ashley Madison if it was in place in 2015. But unfortunately, it wasn't. The directive was in place at that time. And matter of fact, the inadequacy of the drafting of the directive and essentially the missed opportunity that the EU had to, have Ashley Madison come under its own scrutiny and civil and criminal powers as it relates to that regulation or data protection. This was talked about, this was mentioned, this was criticized by another top firm, Pinsons and Masons, and this was written by their head of fintech, Luke Scanlon at the time, which was the 24th of August 2015, just a mere month after the Ashley Madison scandal. Let's look at it. This is what he had to say. In regards to the Ashley Madison, in regards to Ashley Madison's operations, Ashley Madison is owned by signing up to Ashley Madison website. Users agree that their relationship with Ashley Madison is governed by Cypriot law and that Ashley Madison is based in Cyprus. The terms of use also specify that only the Cypriot courts have jurisdiction to hear cases brought against the company. Masons then goes in to talk about the scape of the old EU law, the directive. So it says the EU's data protection directive states that where possible, data processing is carried out by a data controller with an establishment in an EU country, then the processing must adhere to the national data protection laws of that country. Businesses that do not have an office in the EU can also fall subject to the directive. However, where a data controller does not have an establishment in the EU, but makes use of equipment in an EU country to process personal data, then the national data protection laws of that EU country apply. So in this wording, you can see that it's a bit vague. It's saying, well, in the cases of, it says one thing that says that if you're doing processing activities with personal data with an establishment, if you're a controller in an EU country, then you have to adhere to the laws of that country specifically, which, again, this is what we said is the issue with the directive. It leaves an openness to the local law taking effect rather than the EU law, which is more stringent and consistent and better for consumer welfare. It then also leaves this weird, vague loophole for an establishment making use of equipment in an EU country, which has no clarity. And Pinson and Mason at the time scrutinized this wording because if it wasn't for this very vague wording in which there were no examples to use in order to catch Ashley Madison within the EU jurisdiction, they basically lost out on the ability to legally punish. That means that the EU Commission just basically lost their ability to come down on Ashley Madison for their blatant disregard of the right to erasure. Again, if you've seen the docuseries, then you'll see that the way in which Ashley Madison went about their operations was so vastly contrary to what we now understand to be good data protection practices, and which honestly they did understand at the time to be the same, but it's just the law wasn't fast. As I've said, under policy, on the policy of both the directive and the regulation, Ashley Madison should have deleted clientele data when they were told to do so, and they should have been able to offer this. They should have offered this service without the need for a fee, because it was a right to consumers, meaning that it should be a default option. And in conjuncture with that, Ashley Madison also just didn't delete the information. Not only did they apply a fee for what should have been a consumer right, they also did not delete the information. And the CEO confirmed this with BBC at the time, that consumers who paid for this full delete that they marketed as a product or service did not occur. And that did not occur for many customers. They didn't delete anything in regards to some customers. So charging $19 or 12 quid at the time for a full delete, which they knew full and well they weren't gonna do. Wow. We can now see we can now see why this all led to such a huge downfall, which befell Ashley Madison. And that has been Britannia, your policy princess, and this has been our Policy Power Hour. Now you let me know if this was something you enjoyed, if you would like to see this more in the future, and please tell me in the comments if you want more law, less law, more movie, less movie, but essentially I will always try to join the two. So let me know what you guys think in the comments, and that's been me for this video. Until I see you next time, bye my girlies and my gays and my theys and my non-boundary haze.
Here we go. It's all about you. It's all about me. So don't you do. Make it.
Oh my god. Oh, 30,000 years would give you such a kick in the neck.